Morning to everyone. Welcome to Laputra's YouTube channel. So today we are going to talk about right of the transfer and the transferee. So this is section 53A of Transfer of Property Act 1882. So the Transfer of Property Act certainly deals with all the transfers made with regard to the property. So herein property defines immobile property, an asset. It can be a plant, a machinery, or a building, or any other object which is immobile. So herein in the Transfer of Property Act, they define that a person can transfer his property to another through means of a consideration. So, this certainly deals with things which are related to the asset of a person, and an individual does not only include a person but it also includes company and other individual bodies, whether incorporated or not. So, here in section 53A of Transfer of Property Act pertains to transfer of immobile property for a consideration, and it should be in return. For example, if there is a flat which is worth 1 crore of rupees and the transferor, that is the person who actually owns the flat, is ready to sell it to another person who is the transferee. So if the transferee certainly fulfills certain conditions which is laid down by the Transfer of Property Act, he will get the protection under 53A. So if the transferor is ready to sell the flat and the transferee is ready to buy it for a consideration, and if suppose he pays 50 lakh rupees in advance to the 1 crore worth property, he will certainly be given with some rights and duties, like he can take possession of the property and he can exercise his rights over there. It can be a partial right or a full right. He can already take a possession over the property and he can enjoy the benefits. If suppose the property is already in possession and if the sale deed is about to be executed, still he'll get the rights. And if suppose the 1 crore worth property which is made an agreement to be sold, and if there is a contract between the transferor and the transferee and the transferee decides to purchase it, he pays an amount certainly to fulfill the promises, and herein the transferor do certainly have some promises that has to be fulfilled. If the transferor decides to sell it, and further if he is ready to give his possession towards the property to the transferee, then he cannot claim any rights after the agreement is done and if the amount is got. So if the 1 crore worth property is about to be sold and 50 lakh is already paid, the rest of the 50 lakh should be paid by the transferee. But there is an agreement between the both that saying after the 50 lakh amount has been received, the transferor has to execute the sale deed, after which the 50 lakh amount balance will be paid. So in this instance, if the transferor changes his mind and he wants to take back his decision and he thinks that he shouldn't sell it anymore, and on this occasion any person who is related to the transfer, whether or not he is a legal heir or anyone related to him, a legal representative or anyone, he cannot claim a right because section 53A of copyright, because section 53(8) of Transfer of Property Act 1882 decides what to be done and it gives protection to the person who is the transferee. So here transferee has to fulfill the promises to get the protection under this act. So this section particularly deals with the rights of the transferee, and if suppose the transferor decides not to give in the property and changes his minds, he cannot do anything further, even if the sale deed is not completely executed and even if the mother document is handed over to him. So this regards only to the immobile property of the act. So let's get to analyze the case laws which is related to Transfer of Property Act section 53A of 1882. So here, the Transfer of Property Acts section 53A was amended for the 20th time in 1920. So that's the year when this section came into force. This actually gave a protection to the transferee or the purchaser. Until then, it was not given, and they were in a delicate position to deal this problem. So, further on analyzing the judgments, we will get to understand more and better about this. There are few judgments which I read, and that is Nathulal versus Pulchand 1916 Supreme Court case, and another is Ligi Paul versus Mariakutti High Court case, and Rekha Gupta versus Ashok Kumar and others RFA number 279 bar 2018, and Suraj Lamp Industries Private Limited versus State of Haryana 2012. So these are some of the important cases which I went through and I got to study. As you go through this, you will get to understand that when a transfer is made, when a property is being transferred from the transferor to the transferee, any property, I mean any asset which is attached to the property, be it plant, machinery, buildings, and well, or any other things which will give any sort of benefit to the transferor, those rights and those benefits will be automatically transferred to the transferee. So herein, when the transferee starts to take possession of the property, he will get all the benefits. If suppose there is a building and it has been given on a rent, and the transferor was getting profits out of it, I mean an income in means of rent. So when this property is transferred from the transferor to the transferee, now the transferee automatically gets the benefit of rent which is got out of the rental building. This cannot be cancelled, and there can be no means by which a claim can be asked for on behalf of the transferor. So the transferor is held liable to fulfill their promise to make it a valid agreement and a valid sale. So here, Transfer of Property Act Section 53 exactly deals with the protection of the transferee. The transferee has to fulfill all his promises which is laid down by the law to claim a protection under this act. If the transferor therein does not fulfill his promises, then he cannot state that this sale is invalid or void, because when an amount of consideration is passed from the transferee to the transferor, then that suppose he is liable to give away the property as agreed in the agreement, and it is mandatory to have a contract between them, and if an agreement is laid, then there should not be any breach. If there is any breach on behalf of the transferee according to the contract act, then he cannot supposed to claim protection under this act. In the Mariakutti case, the High Court held that the law should be followed in respective way in a proper means. That is, the transferee has to make an agreement with the transferor, and it should be enforceable by law. Any contract or an agreement which is void cannot be taken for an appeal inside the court stating that there was a deed sale between us and I promised to purchase it. So here it is said that section 53A is called part performance. What is part performance? Where any person contracts to transfer for consideration any immobile property by writing signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and transferee has to. So this cannot be read separately, and it has to be parallelly read with contract act and sometimes in case of tax. So this is correlated with everything, and the transferor and the transferee has to make sure that all the compliances and all the rules and regulations are followed strictly to avoid any sort of misunderstanding and misconception. So this doctrine of part performance specifically explains what has to be done to make this a valid sale, or if at all if it fails to do a valid sale, then the rights of the buyer can be protected. So that's it guys, let's get to meet in another video. So please do like, share and subscribe to our channel Laputra. Thank you.